By popular demand, here is the very simple explanation as to why Meghan Markle has not yet won the claim against her sister. Welcome back to the channel. So many of you following our live stream, thank you very much for joining us for that. I will link that in the description below. Have asked the question in very simple terms, why it is that this case as against Meghan Markle by her sister Samantha Markle is not yet over, is not yet concluded, and why ultimately she hasn't yet won. So in this video, a very simple and concise explanation as to why that is. So in the US and England and Wales, we have similar processes in the courts whereby the court can strike out a claim or a defence or any statement of case if there are no grounds for bringing the claim or no grounds for defending the claim. Now, in the US, there's a distinction between dismissing a case with prejudice and without prejudice, whereas in England and Wales, we can strike out a statement of case, but then we can have an application to set aside that strikeout. And I'll come to the difference in the two in a moment. But dealing first of all with the US in broad terms, and then I'll move to the case with Meghan Markle and her sister Samantha Markle. In the US, there are two different types of a dismissal of a claim: dismissal with prejudice and dismissal without prejudice. Now, broadly speaking, dismissed with prejudice means that the court has made what we call a final determination of the issues or the merits of a case, and the plaintiff, the person bringing the case, is barred from filing another suit on the same facts or the underlying cause of action, or from amending the claim with better or new particulars. In other words, that's the end of the matter. The court has made a decision, it's dismissed the action with prejudice, meaning that is it. It's a final judgment, and you cannot bring another claim either within the same proceedings or in the future on the same underlying set of facts. Now, that's with prejudice. So without prejudice clearly means the reverse, i.e. the case currently stands dismissed, but without prejudice, meaning that the plaintiff, the person bringing the case, as in England and Wales it would be the claimant, can bring a new claim or within the same proceedings, but with renewed, different or repleaded particulars to set out the case once again, to have the court consider it a second time. In England and Wales, we have a very similar procedure, what we call a strikeout. So if someone were to bring a claim that just discloses no basis in law to bring the claim, there is no arguable case, the court can strike out that claim on the basis that it provides no basis for the claim in the first place. The same can apply to any statement of case, which is the claim, the defence, the reply, and so on. So if someone files a defence which ultimately provides no real defence in law, even on the basis of facts, if the facts were true, still provides no defence. If the defence just simply says this is what happened, but that provides no defence at all, then it's not a defence. Then the case can be struck out, the defence can be struck out by the court on the basis that there is no defence provided. So either the claim or the defence can independently be struck out by the court on the basis that there's no claim provided, or it's not properly pleaded, or the defence provided doesn't provide a proper defence. Now in England and Wales, we can apply to set aside that strikeout, that decision to strike out the claim, on one of a number of different arguments. I won't get into those in this video. On the alternative, the court can provide permission that the claimant replead their case, as in they draft better particulars, just replead their case properly. This is usually where the court considers that there might be a claim to be made on the basis of the underlying facts, but at present, the case isn't properly pleaded. Therefore, that claimant has permission of the court to replead their case, usually within 14 days, to provide a proper statement of case, to go away, probably get a lawyer and plead the case properly and bring it back to court. and then see whether the court accepts that this repleaded case has merit. In the alternative, with a defendant, the same can apply. The court can say, as it stands, your defence filed doesn't provide a legal basis of a defence. Therefore, go away and get your defence repleaded with a lawyer, and then come back and perhaps your defence will have some argument. Not to say that that is then upholding the defence and saying the defence wins. That's not the case. The court is merely saying at this point in time your case may have a valid defence which can then go to trial, because all of this is before you get to trial. So the court may say, go away, replead your defence, come back. If the court accepts that there is a basis of the defence, then we'll come back and hear it at trial. Now, in the US, that is exactly the same thing. It's just different terminology. So dismissed without prejudice means that the plaintiff, or the defence of the case might be, can go away and replead their part of the case and come back to court, and the court will determine whether or not that's then a valid case to plead. So moving now to the Meghan Markle versus Samantha Markle case. This is why we said the media was wrong, with respect, in saying that she's won the case, that's it, game over, because that's not true. And the reason is as follows. So we move to the document, which is the order by the US District Court, providing the order here. Let's move down to the conclusions. For the foregoing reasons, etc., etc. Accordingly, it's ordered motion to dismiss for failure to state a claim. This is what I was talking about here. Failure to state a claim. This is where we would say that the particulars of claim provides no basis for a claim, no underlying claim is granted. So this is our equivalent in England and Wales of a strikeout. So this is the claim is struck out. However, the plaintiff's defamation claims based on the contents of the book, Finding Freedom, is dismissed with prejudice. This means the court's made the final determination. You cannot come back and argue new or better particulars. However, plaintiff's defamation claims based on the CBS interview and injurious falsehoods are dismissed without prejudice for the foregoing reasons. So, meaning plaintiff may file an amended complaint within 14 days. Now, whether or not Samantha Markle does come back and file amended claims on this second portion is what we will wait to find out. But that is why that this claim in its entirety is not over. So in very simple terms, that is why the media broadly stating that this case is over, Meghan has won, is not quite true. Now, of course, if within this 14 days Samantha Markle doesn't amend her complaint, her claim, within this 14 days, then that is it. That is the time limit, and unless there's any argument as to why that should be extended, but of course I don't practice in the US, so I can't really answer that. Maybe some of our international US attorney friends will help us out. I'll perhaps tag some of you in the comments, description below, so you can comment on this, come back and let me know what you think about that, whether there's any case for extending this 14 days or after this 14 days has expired. Question, could this be what we would call relief from sanction? Because sanction would be that that's it, the case is finished. After the 14 days, is there any basis upon which they could come back and say, well, we need more time? Potentially, I don't know. I'll tag some of you in the description and the comments below. But overall, that is why the case is not yet outright done. And the difference between the US and England and Wales, because I know some of you are interested in that. So the striking out of a claim and repleading better particulars. And as a final note, once a case is done, then that is generally it. You cannot come back to court, whether in the US or in England or Wales. You cannot come back later. This is sort of akin to the double jeopardy argument. You cannot come back later and say, actually, I want to try again. Only this time I'm going to bring new particulars of claim, a new basis of complaint, new evidence, better evidence, and this is why I should win the second time round. That doesn't work. In England and Wales, that will be struck out on a different basis, on the basis that it is an abuse of power, abuse of the court's power, attempting to replead a case on new or better particulars. We don't allow that, and I presume that's the case in the US as well. So I hope you found that interesting. Please do smash that like button and subscribe, and I will wait in eagerness of our US attorney friends, Lawtubers, to come back and comment on this 14-day thing. In the meantime, thank you for watching.